G'day there guys, it's your Aussie Hubby Markee, back at it again with another r/legal advice video. Now if you love me as much as I love you, then you know what to do. I want you to mosey on over to that old like button and tackle it like Crocodile Dundee. Maybe even chuck an Aussie flag down in the comments, maybe a kangaroo too if you're feeling a bit spicy today. And now with that said, I want you to sit back, relax, chuck a prawn on the barbie, and get ready for some bloody good legal advice. Now our first post is by user Mia Hep, titled, "Second time in 2 months that the same Las Vegas hotel has served me, 3 years sober and not ID'd, booze when I ordered a soda." Now, the first time I messaged their security and got an extremely apologetic phone call with an invite to come back for a few nights and comped several $100 dinner in one of their restaurants. More than kind, right? He said they could get in a lot of trouble for this, so they wanted to make it up to me. It's night 2 of my stay here, and I ask a waitress for a Sprite with mint and lime. I was clear I didn't want a virgin mojito, just in case that was too confusing for the bartender. A few minutes pass, she gives it to me, and like an idiot, I take a big gulp. Yup, that's right, going on 4 years sober, and I just swallowed my second gulp of booze. Thanks to the same hotel's inability to, I don't know, make a soda? So what do? I had to unfortunately go through weeks of counselling after the last mistake. I just feel absolutely let down and disgusted with myself and whatever bartender made my Sprite. Legal advice, you have no damages under the law really, unfortunately. The most you can do legally is report them to relevant authorities for their liquor license. Non-legal advice, this has not ruined your sobriety. Your will was not broken, and you're still dedicated to keeping yourself healthy for yourself and your loved ones. Do not let this make you feel broken. If you need to, look for an AA meeting in town, just to talk about your feelings. Or, if you have a contact you talk about stuff like this with, reach out to them. Nothing is down the drain. Honest question because I don't know anything about the law. Whenever folks end up here discussing putting laxatives in food as a prank, they're told it's clearly assault or battery. Is this case not similar? If they investigate and it's an accident, okay. But if someone is maliciously doing it, isn't it in the battery realm? So most torts require intent or intentional/extreme negligence that caused the injury, intentional torts. If someone were to do it intentionally and there was an injury, there may be a case under tort law. Legally speaking, they owe you for your money back for the drink you ordered and weren't served. If they comped the drink, then they don't even owe you that much. You could try to pursue your counselling expenses, but it's not clear that you would prevail in court, although they might cover them voluntarily. However, you may want to make a second complaint to the management and to the county about their practice of serving liquor to patrons who have not ordered alcohol without informing of them. Congrats on your sobriety. The first time round, the manager said legally this could be very bad for them, so he would prefer to invite me back. I would imagine this could also cause some sort of problem. I mean, legally, can I force them to do some sort of courses for accuracy and importance of sobriety? And I don't know. I'm just so upset. I don't want a refund for my drink, I want a refund for my sobriety. I would not accept a second invitation back, for the exact reasons you identified. You already gave the establishment a second chance and they blew it. Escalating to county regulators is an appropriate next step. They won't be forced to do anything specifically recognizing sobriety or teetotalism, but they may be forced to start respecting people's orders, or may be fined or have their license suspended if they are violating state laws regarding responsible bartending. Thank you, that's all very good advice, I appreciate it. And our last bit of advice from Silver Bridges. Not your lawyer, not a Nevada lawyer, but I agree with what others suggested about legal issue. Likely negligence, possibly battery, possible emotional distress cause of action. Intentional or unintentional, I say possible because different states have varying thresholds to meet on this. Possible punitives, have to go to trial to affirmatively get those. As the casino, they are going to be most concerned about the negative publicity if you do go to court in this, as well as the potential censure as it relates to their licensing, liquor and casino. My hunch is that the situation, given it occurring twice, has the casino much more willing to take care of you, and bar manager scrambling to not lose his job. I frankly wouldn't leave it at the bar manager level and have a meeting with higher casino management. I would hope you would get a lot more than a dinner comp, etc. out of this, but it sounds like you're less focused on what your compensation might be than the emotional side of it. Additional non-advice. Lots of good perspectives on how to handle this from other recovering addicts in this thread. Best of luck. Now, OP has 3 updates on this post. Update 1. The head of the alcoholic beverage department called the manager on staff back, which is surprising because it's midnight. He said he would appreciate if we don't go home, as he will come in the morning to speak to us because he feels this has escalated to a dangerous situation for both the hotel and me. I have no clue what that means, but I'm assuming the video they found of them pouring booze into my cup, then the video of the waitress clearly telling me that my drink was virgin, has something to do with it. Or the fact that this mistake is the exact reason they even invited me back. Who fudging knows? They just had me fill out a statement. I have the drink here in the room with me. I don't know why, I just need to sleep. I've been crying on and off for hours because yet again I am left wondering if 3 years and change of sobriety is now down the drain, and I need to forget the taste of that strong-ass drink going down my stupid-ass throat. Second update. I met with the manager today, and he said he will do anything to make this up to us and keep it from being talked about outside of the hotel, whatever that means. I just thanked him and told him I'd call if I need anything. Thank you everyone for all your replies. It's not the end of the world, just extremely dangerous and negligent on their part. I spent most of the night crying, thinking what happens now. Do I relapse? But luckily I woke up feeling normal and just as committed to my sobriety as I was before that gulp. His comments made me think he or the boys are afraid of something happening. I don't know what, but if there is something more I can do to ensure this doesn't happen to anyone again, I want to do it. Like contacting the departments you guys have provided in the comments. Thank you again. Third update, I don't think anyone will see this anymore though. I posted my experience on Facebook and it's been shared quite a few times. CNN called me today. A few attorneys have reached out urging me to pursue a case. I really don't know what to do. And the takeaway from this is they didn't do anything. There is no other updates, there are no further comments from the OP. So the safest bet here is that they took a deal with the actual bar manager and they sorted it out within the club. Obviously I can't say that for sure, but I think it's a reasonable thing to expect of someone in this situation. Now our next post is by user Listening Heads, titled Almost Heaven, West Virginia, possibly being fired from bank tomorrow morning for discussing wages. First of all, thanks to anyone who takes time to read this. I have a meeting at 9 AM tomorrow morning with the bank president, HR manager, and ops manager. They sent me home today with pay after a brief scolding. They are very angry that I discussed my own and others' pay rates with a fellow employee. The issue at hand. Employee A told several people they had a job offer from a competing bank for $14.75 an hour. Employee A told the bank president, and so he raised their pay to match the other offer. Employee A told me about the raise and that they were not leaving our bank. I told Employee B everything until Employee A had told me. Employee B has been at the bank several years more than Employee A and was furious due to their much lower pay, undisclosed to me. This morning I was called into a meeting where I was told to leave and my fate would be decided tomorrow morning. I'm not proud that I caused drama, but I also don't feel that I did something to warrant termination with no prior offenses. As an aside, everyone at the bank discusses other people's salaries and wages. I'm not certain why I am the one taking the heat. Any help would be greatly appreciated. Sorry if I let anything of importance out. First, no, you cannot be fired for discussing your pay with fellow employees. The US has very few employment protections, but amazingly, this is one of them. Do not tell management that it is illegal to fire you for this until after you have the reason in writing. Email, text, etc. West Virginia is, I believe, a one-party consent state, so I would get a cheap digital recorder or use an app on your phone to record the meeting. Play dumb instead of arguing. Make them spell out exactly why they are firing you. Make them tell you it was wrong. So, it is against the rules for employees to discuss their wages? Or even better, I didn't know it was against the rules for employees to discuss their pay. because these types love to point out some handbook passage or explain in great detail that it is wrong and they are right to fire you. Give them enough rope to hang themselves. Then, go immediately to an employment attorney and witness the justice boner. Edit: this only applies if you can afford to be fired. If not, still try to get it in writing and record the meeting. But if I needed the job because I was paycheck to paycheck, I would fight like hell in that meeting, and I would point out that the NLRA applies, then discussing wages is absolutely protected. Even discussing third-party employee wages. If you need it, tell them they cannot fire you for this and that we should all just go back to normal, then immediately start looking for a new job. Now, this only applies if you can afford to be fired. I would argue, if user listening heads can't afford to be fired, then your advice is even more pertinent. If they have a recording that states that they are getting fired for discussing compensation, then they have at least some chance to fight back. They won't be reinstated into their job, but they'll receive adequate financial compensation. On the other hand, if they immediately mention that they know their rights, then there is a good chance the manager is simply going to make up some random excuse. E.g., you are very inefficient and have a tendency of wasting time chatting with your co-workers instead of working. That is a perfectly reasonable explanation to let go of an at-will employee, and it'll be so much harder to fight later. Unfortunately, and to be perfectly blunt, if the manager has already made up their mind to fire listening heads, there isn't much that will stop this in either case. The best that can be done is mitigating damages. If they do terminate you, go immediately to an employment attorney. I would probably hesitate arguing your case to them and telling them it's illegal. That may give them an opportunity to amend their reasons for termination, and do not sign anything. OP replies to this: what if they give me the chance to resign instead of being fired? In the meeting, I argued that their own training DVD stated I was allowed to discuss wages. They didn't believe me, but they may know they aren't allowed to fire me. So I want to be prepared for them trying to kick me into quitting. Just be firm that you do not wish to resign. I'm sure they would love to have documented that the reason for your leaving was that you resigned and not for good cause. Again, don't sign anything. And now on to our update. I was fired for discussing wages. So I had a brief meeting with this HR and CEO. He said I no longer work there and I could choose to resign or be fired. I recorded the conversation. They chewed me out for discussing another person's wages. Then I asked what the actual grounds for termination were. They replied that I violated 3 company policies, and when I asked them how, they would only repeat that I had violated 3 policies. I told them I couldn't resign, so they stood up and walked me out the front door. Ooh, that's a really harsh ending to this one. Jesus Christ. Well, there's your resolution, guys. I hope you're happy with the end of this story. Alright, and on to our next post by user Leslie Powers, titled, Ex-landlord trying to move people into our old apartments while we're still paying rent on it, and keep our deposit. So, I live in Denver, Colorado, for reference. My wife and I recently signed a lease on a new apartment. We have paid rent on the old apartment up until January 31st, so we are not fully moved out yet. We still have some belongings at the old place and haven't finished cleaning it. Our lease ends on the February 1st. We told our landowner we would be moving around January 8th, so that he would have time to find a new tenant. I already told him that if he wanted someone to move in before the end of January, he would have to give us the pro rata rent for the rest of the month, and give us enough notice to fully move out. And he agreed. I just got a voicemail from him telling me he has someone moving into our old place in 3 hours, and that they are not refunding our deposit because the blinds are dirty and the garden needs weeding. Both were things that we were going to do before the end of the month, of course. Our deposit was $1,200. To really rub salt in the wound, the place was a crap heap when we moved in, and we had many improvements to it at our own cost, such as fixing broken windows, repainting dirty walls, replacing broken fixtures, etc. We have lived there for 2 years, and he has consistently told us what excellent tenants we are, and how much he appreciates the care we take of the property. So, you could tell him that you aren't relinquishing the apartment until your lease runs out on February 1st. If they wish to break the lease early, then you should talk to a local LL/tenant lawyer about suing your landlord for breaking the lease. Do you know if there's some kind of clause I can end my landlord so he knows he's not allowed to do this? This is his only property and he inherited it, so I don't think he really knows what he's doing. But I really can't afford to hire a lawyer. The simple fact that you paid gives you a full and complete access to the property until the end of the lease. No lawyer needed, just let him know that if anyone shows up prior to February 1st, the police will be called and you'll trespass them, / have them arrested for breaking and entering. And Salad and Eggs says, your landlord has 30 days to either refund your deposit or provide you with an itemized list of charges. If he fails to do that, you can sue for up to 3 times the amount held. You can also dispute the charges. As far as the 3 hours notice, that likely amounts to an illegal eviction. And update, thanks for your advice everyone. I decided to go the old-fashioned route and told his wife. She said we should ignore him completely, that they would pay someone to clean and weed, and is bringing us our full deposit check and pro rata rent for the rest of the month this evening. Who runs the world? And our next post is by user Tiny Teaching, titled, How do I help my underage cousin get an abortion in Mississippi? So my brother and I are trying to help our 16-year-old cousin who is pregnant to get an abortion. We are 22 and 23 years old. Her parents cannot know that there ever was a pregnancy. I believe there's only one clinic in our state, and we called them, and they said parental consent is absolutely necessary. In fact, both parents must consent. A single one is not enough. They also said that a judge might allow it, but they will want to speak with the parents before they make a decision. What legal choices do we have here? Is it legal to take her to another state to get an abortion? If so, which neighboring states would allow her to get an abortion without permission from parents? We live in Biloxi, Mississippi. Summation of accurate advice. Get your cousin to a place that does not require parental consent. The nearest to you is DC. Make an appointment in advance. Make sure it's in DC proper, not Virginia, as many places very near DC label themselves as being in DC, but are just in MD or VA, and you are not breaking any laws. Also, there are more clinics than just PP there. Look around if you can't get an appointment and read Yelp reviews. Yes, that's a thing. Obligatory, I am not a lawyer. It seems Connecticut is your best bet, and no, you can't transport her over state lines without parental permission. But you can transport her with permission, and simply not let them on that your ultimate goal is to have her receive an abortion. I don't know what your financial situation is, and this is probably a long shot, but if you can go on vacation with her parents' knowledge of that trip, but not the goal, to another state with no parental permission required, get your cousin the abortion she needs, and come back, then you would be in the clear. Make it a road trip, if you can drive. Buy plane or bus tickets if you can afford them. There's plenty of faux touristy things to do in Connecticut. I commend you for helping your cousin in her time of need. I was actually thinking about going on a so-called vacation, but the other commenter said that it's still illegal to do if it's under false pretenses. It seems the other reply was mistaken and has since been removed. That's such a relief. And now, an update to that post, thanks LegalAdvice. So I would like to thank you for your excellent advice, which allowed us to help our cousin. A few days after my post, we asked her parents to allow her to come with me and my brother to DC as a cousin bonding trip. They were open to it, and even ended up paying for her ticket and driving all of us to the airport. We took mandatory pictures at all the usual places to make it seem genuine, and then went on to the abortion clinic, which we had previously booked an appointment. Everything went smoothly, and the abortion was performed. The next day, our cousin wasn't feeling well, but we had a day for her to rest before coming back, so it was fine. We paid for the abortion ourselves, although her parents giving us money to spend for this trip helped cover most of the cost anyway, as we really didn't do anything else, so we didn't need much money. Thanks again. Now that it's over and the abortion is behind her, and she's recovered, I've had a chat with her about birth control, and we're making sure this doesn't happen again, unless she herself wants to get pregnant, of course. She's also dumped her boyfriend, who completely ghosted her ever since hearing she's pregnant. Alright, and our next post is by user, Is This Toxic? Titled, Tricked into eating something I don't eat at work. Is this illegal / a toxic work environment? So, this is Alabama. I'm really upset over all of this, so I'm sorry if it doesn't make sense. This happened last week and it was only brought to my attention today what exactly I ate, and I'm a mess. My co-workers all cook a lot and bring in food for everyone. They all know I have food restrictions because I usually don't partake, which pisses most of them off because it's rude. One girl brought in a pie and was very proud of herself saying that I could eat it. So I did because I'm a trusting idiot. My stomach was a wreck that night and the next day, but I'm pregnant and having a weird stomach anyways, so I didn't connect the dots. There's been some other crap since, and I'm on even stricter rules right now. One of my co-workers was commenting on it all day today after seeing me eat my sad work dinner, and said outright that it isn't the end of the world if I eat stuff I'm not supposed to, because a lightning bolt wouldn't come from heaven and kill you. I sort of gave her a look, and she laughed and said it didn't when I ate the pie and told me what was in it. I'm so upset right now. I genuinely don't know what to do or say. They've ignored my wishes and have been outright hostile, but never like this. I went home crying last week over something else and filed with HR over it, but they didn't take it seriously, and this is just my breaking point. I'm not coming back after I have this baby, but is there something I can do legally? TLDR, co-workers put something I don't eat into food and lied about it to me, saying they specifically made it safe for me. Now they told me they did it to prove a point. Do I have legal recourse? Wait, are you the person who was upset about the unwelcome work baby shower because baby showers are not consistent with your Jewish faith? Wait, what? Is this one of the prior incidents that you were referring to? How the hell did you know this? Gin Roast made a hell of a good connection, and given your statements, he honestly believes that the perpetrator of a previous incident regarding your posted here, he's on the ball on this one. Seconding the motion to get the other thread and to go to a lawyer. You may actually have a case of religious discrimination that's actually actionable here, and if the facts line up, pretty much any lawyer is going to salivate at this because it'd be such an easy case. HR failed you, so that is your next step. And practically, once you begin this step, you'll probably be out of a job, so I'd begin looking for other opportunities. That part might be considered a retaliatory firing, and you would certainly have a case there too if that is the case. That will depend on your local laws though. And if I could, I would definitely read that little thread that they had going there, but it got removed, unfortunately. So I can't read that baby shower story with the hostile work environment, sadly. Also, Derspany, very good quality contributor, says, if your co-workers intentionally fed you things they knew would injure you, then you were assaulted. However, it's often difficult to get the police to care unless the harm is severe or unless the nature of the adulteration is clearly dangerous. If the restriction is more like soft cheeses make me ill because I'm pregnant and my stomach has gone weird, and less like arsenic makes me die, and if you don't have any medical bills to worry about as a result of someone feeding you the wrong food, then legal action is probably out of reach. However, this is absolutely an HR issue and an internal policy issue. If you're on a restricted diet for medical reasons, it's absolutely reasonable not to be harassed about it at work. It's likely worth talking to HR, in writing, keeping a copy for yourself, specifically requesting that they speak to specific people about harassing you about your diet. Going forward, unfortunately, I think you'll have to hard refuse any offers of food from your workplace, simply as a safety measure. And since you're moving on from this job, that won't be difficult. It isn't a food allergy or medical, it is a religious restriction. Okay, religious harassment is a bona fide hostile workplace issue. If HR blew you off when you requested that they put a stop to it, it might be worth speaking to an attorney. The company's, and thus HR's, responsibility is to put a stop to harassment on the basis of your religion, whether that means having a polite word with the offending colleagues or taking further steps. A paper trail showing clearly that you asked HR to intervene on what certainly looks like harassment on the basis of your religion will help you if your company doesn't address the problem effectively. I've asked them to intervene multiple times on religious harassment. The only times they did when I was reprimanded by my manager for wearing religious clothing, a headscarf. And now, tricked into eating something at work update. So I keep getting messages asking for an update. I can't say much, but I have gotten a lawyer through a friend of the family. He has contacted corporate HR. There will be a settlement out of court as they want this resolved quickly, and with no publicity. I cannot express how grateful I am for all of your quick thinking and ability to connect the dots. I don't know if I would have had the guts to get a lawyer if you hadn't said anything. Thank you. And now our last post for the day. From Dumb Car Accident. Richmond, VA. I caused an accident a year and a half ago. Injured party refusing settlement from my insurance company. She's demanding that the money come from me so that I can know the pain she feels. Richmond, VA. So I am dealing with a smallish insurance company, and they have been wonderful to work with, and they have been communicating with me. They told me that I do not need to take any further action at this point in time, but I wanted to get some understanding as to whether or not this lady has any legal ground to stand on. A combination of nasty weather, my unfamiliarity with the area I was driving, and speed on my part caused me to be at fault for a car accident. I ended up rear-ending a woman. My car is a 2008 Honda Civic, her car is a 2014 Ford Expedition, at around 35 miles per hour on a 25 mile per hour road. She was moving at about 10 to 15 miles per hour at the time of the rear-ending. My car was totaled. Her car needed barely $2,500 worth of repairs. This woman has racked up what amounts to something on the order of $25,000 worth of medical bills. This spans chiropractic appointments, to home and doctor office-based physical therapy, etc. Her medical insurance has covered all of this at this point. Last week, my insurance company reached a verbal agreement with her and her lawyer for $40,000. She is now refusing the money from the insurance company. She is demanding that the money come from me personally. She thinks that this will help me learn my lesson. My insurance company shared with me a letter she wrote them, a 12-page, front and back, what I am calling a manifesto. No, I am not posting it here. I would also like to point out that she's 24 years older, and the letter makes it sound like she's an 84-year-old woman on her deathbed, with all her listed ailments. I am not trying to diminish whatever pain she's in or thinks she's in, but come on, right? So does she have any legal standing on her demand that I pay versus my insurance pay her? No, she can demand it, but your insurance will pay in the end. That's the point of insurance after all. I don't even get what she'd be suing for anyways. Say she is awarded the judgment, the insurance company could just give the money to OP and OP pay the lady. Would she even know? If she sues you personally, your insurance company will provide a lawyer who will show she was sent the money but refused it. I can't imagine her lawyer or insurance company is too happy with her right now either. If she declined a genuine offer of the payment, what happens from here? Can her case be vacated if she refuses the payment simply because it comes from the insurance company rather than the individual? I know in some cases, if a demand is met and then refused, the whole issue gets thrown out. Probably her attorney accepts payment on her behalf and holds it from her until she stops being an idiot. Yeah, the woman I have been dealing with at my insurance company said she thinks that her lawyer and insurance company were not aware of this letter. That would make sense. I doubt that a lawyer that has even a rudimentary understanding of insurance would approve of that type of letter. In fact, it just makes her look bad. A very similar issue occurred recently in the US, can't recall where. A driver lost control of his vehicle and crashed into a fence on private property. The driver accepted full responsibility for the accident and offered to pay for the repairs of the fence and lawn, an amount over and above the cost of the contractor's quotes. The owner of the fence declined it and decided to sue for an amount way above repair costs. The judge tossed the case because the property owner had offered a reasonable and full settlement. In the end, the property owner was stuck with the repair costs. And someone else says here, she can demand all she wants. Your insurance shields you up to your coverage limits from this type of stuff. If she and her attorney settle, that's it. Case closed. And in regards to her having any legal standing on her demand that I pay versus her insurance pay her, not really at this point, based on your story. So what happens if, months down the line, this is still an issue? She made it very clear in her letter that unless we can prove the money came from my bank account, she will refuse the funds. The case will go to trial, a judgment will be entered. Your insurance company will pay the judgment. She can accept it or refuse it, but the matter will be closed. And now, what you've all been waiting for, the update. So, the lady I hit for several weeks refused to take the verbally agreed upon settlement, and my insurance company put it on the back burner. In June, they gave her 30 days to respond or they would rescind the offer. In the middle of June, she hired a lawyer not connected to her insurance, rather than a personal injury attorney. I got a letter from the law firm telling me that I was going to be sued if I did not compensate the client the $40,000 she thinks she's owed from the car accident. I kicked the letter off to my insurance company. I first called, then emailed it. My adjuster that I was working with had an audible after I read him the letter. Then a strained chuckle. He says, "We'll take care of this." I heard back from them on Wednesday the 5th. They sent all documentation of the accident, the audio recording of her verbally agreeing to the settlement amount, and her manifesto to her newly hired attorney. They apparently also included a note that stated that they were giving her until the end of June to accept the money, or they would rescind the offer if she did not get this taken care of soon. My adjuster called me this morning to tell me that the issue has been resolved. She has signed an agreement yesterday that she cannot sue if she takes the money. According to my adjuster, they re-offered her the $40,000 because of two things. Primarily, they wanted this to go away and they did not want to be sued for more. Second, they apparently know of this personal injury attorney. He requires a very high contingency percentage, and this woman essentially played herself by hiring someone that was not necessary. He collected on her behalf and took his cut. That's all I know. So yeah, issue resolved and my insurance has jumped up a small bit in cost due to the accident. Alright guys, that's all for today. Tell me what you thought of these legal advice stories. I know there was a few comments, but I usually go for the ones that the OP replies to because it continues to add to the story more and more. And I won't cut those out because that's more backstory that goes into the updates and I feel like you need it. Anyway guys, tell me what you thought about this one today. I really hope that you had a good day. I like your feedback and I like knowing what you're up to. Also like my memes on the community page because they make me happy. I guess that's all I have to say for today. I wish you guys all the best during this quarantine, and I hope you have a good day, night sleep, whatever you're up to, and I'll see you in the next episode. Bye!